Things escalate fast right from the start as the courtroom cuts straight to the core of the case. What seems like a routine proceeding suddenly shifts when the prosecution admits they can't move forward on key charges. That alone raises questions. What went wrong behind the scenes? The defense wastes no time and pushes for dismissal, signaling confidence. Then comes the turning point. The judge agrees and drops counts 1 and 2. It's a sharp, unexpected moment that instantly reshapes the case. For anyone watching, this is where curiosity spikes because something serious just collapsed. And just like that, the tone of the entire hearing changes.
Cantor, can you please state your name?
Joseph Hafner Cantor.
All right.
This is the daytime set for preliminary examination. As it relates to counts 1 and 2, the people are unable to proceed. I would ask for remand.
Your Honor, the defense would move to dismiss with respect to count 1 and 2.
Now the spotlight turns to the defendant's personal struggles, and things get real. The defense openly admits that earlier arguments about the defendant changing his behavior were overly optimistic. That kind of honesty is rare and revealing. We hear about repeated alcohol violations, even during court proceedings, which paints a troubling picture. There's an attempt to rebuild trust with new safeguards, but the damage feels heavy. The judge listens carefully but remains firm, showing no signs of leniency. When the bond request is denied, it lands hard. This moment isn't just legal, it's deeply human, showing consequences catching up in real time.
2 are dismissed. I'll continue his not guilty pleas as to counts 3 and 4. This will be set for pretrial on January 26.
Yes.
January 26, 2026. Time, I'm sorry. 1 p.m. before Judge Freshour. Bond continued.
Your Honor, may I be heard with respect to bond?
Yes.
Thank you, Your Honor. Mr. Hafner Cantor's bond was revoked at the last hearing he had before this court. Mr. Hafner Cantor had admitted to several SoberLink violations, including one that occurred at the same time he was in court for a misdemeanor OWI. And Your Honor, at that time, I think the argument we made was a little naive. I think we were asking this court to find that Mr. Hafner Cantor had had an epiphany and was going to cease drinking on his own volition. Since that time, I've had a discussion with Mr. Hafner Cantor about putting some safeguards in place to ensure that he does not begin drinking again. And Mr. Hafner Cantor admits that he does have an alcohol issue. Your Honor, Mr. Hafner Cantor, his SoberLink was previously, in the other case, a scram tether was ordered. But in addition to that, Mr. Hafner Cantor previously attended AA meetings at the St. Paul Church in Saline.
Can I just say something?
Yes,
Isn't he before Judge Freshour on the OWI?
That's correct, Your Honor.
Yes, Your Honor.
And so it would seem to me that she might be better equipped if I just leave it where it is to deal with the violation here. Quite frankly, that's what I'm thinking.
I understand the court's position. I did talk to Mr. Hafner Cantor, and I think he knows that this case is now going to be remanded to the same judge. But he does want me to ask the court to reconsider bond. It was initially set at $5,000 personal. I would ask the court to consider reinstating that. I know that a referral has been made in the OWI case to the district court sobriety court. And
which also Judge Freshour handles.
That's correct, Your Honor. So I'd ask the court to consider it, but otherwise, we would renew our argument before Judge Freshour.
I am not, I don't need a response from people. I'm going to deny your request. I'm going to leave this bond as revoked. You can address all of that, the drug court, as well as OWI, everything. You can address it before Judge Freshour and let her make that decision.
This is where tension truly peaks, and you can feel the weight of the decision building. The defendant considers pleading guilty, but his reasoning raises concern. He just wants it over with. That's a dangerous mindset in a courtroom, and the judge immediately steps in. There's a clear effort to ensure this isn't a rushed or pressured decision. The defense even offers to proceed with a full examination instead, showing readiness to fight. The uncertainty is intense, with the defendant trying to understand the consequences. Finally, the judge pauses everything, giving him time to think. It's a powerful moment of pause before a life-impacting choice.
Thank you, Your Honor.
Thank you.
All right.
All right. I have your name, sir.
Marshan Smith.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting obstruction, 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge.
All right. Have him sworn.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Okay, I do.
Lower your hand, state, and then spell your name.
Marshan Duell Smith, MARCHAND DUELL SMITH.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? You need to.
Yeah.
Okay. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B district court. Do you understand that?
Yes, I do.
Still wish to plead guilty?
To get this situation over with, Your Honor, like I mean to get this situation over with.
Your Honor, we're perfectly ready to hold an exam if Mr. Smith does not wish to plead guilty. I don't want him pleading guilty simply to get something over with. If he wishes to plead guilty, I'm happy to stand here next to him and do that. But if he doesn't, then I'm happy to hold the exam.
What do you want to do, young man?
Is it possible for at least for the month that I spent in there, I spent over at least 35 days and they're trying to get out on personal bonds. Then, you know what I'm saying, ended up with a personal bond on the 8th, didn't get out on the 8th, just got out yesterday. Like
You're talking about sentencing as opposed to the plea.
I mean, yes, you know, if I can get time credit for the time that I did spend.
I'm not the sentencing, so I can't say I'm going to give you credit for time, sir.
And I have explained to him that he will get credit for the days he spent against any jail sentence, which I'm not anticipating here, but there's no promise from the prosecutor or, obviously you can't bind Judge Washington, but I've explained to him that he would certainly get credit for the time he's there, but there's no promise of a credit for time served only sentence.
But if I do proceed with the proceedings, then
if you what?
I say now, if I do proceed with the proceedings, then I would get what? Like,
you mean with a preliminary exam? If you do that, what are you? I'm trying to figure out what you're asking.
If I do, you know what I'm saying, take the preliminary exam, I mean, what would happen? What will go?
Well, I don't think anybody can say what will happen, but if the people show their case, you'd be bound over to circuit court and you'd then go to appear on what effectively is a what's called a high court misdemeanor or felony charge before Judge Conkey.
And if I may, we made the misdemeanor offer that is available for Mr. Smith today. I cannot promise that that offer will be made again in circuit court.
Listen, young man, again, like I said, I have to make sure that folks understand what they're doing and whatever. So here's what I'm going to do. I know exactly where we left off in this plea. I'm going to step off for 15 minutes. I'm going to let you have another conversation with your attorney and then decide what you want to do. Okay? They got their witnesses here. Everybody's ready to go. Or you can take the plea or not listen to me and start walking away. All right. Okay, court's going to stand in recess.
Now comes the moment where everything becomes clear and the truth is laid out plainly. The defendant confirms he is acting voluntarily, removing any doubt about coercion. Then the judge carefully walks through the incident, step by step. What follows is a straightforward but critical admission. The officer gave a lawful command, and the defendant chose to run. That single decision defines the case. There's no dramatics here, just raw accountability. It's the kind of moment that locks in the narrative and seals the legal direction. From here on, the case shifts from questioning to consequence.
All rise.
Parole.
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No,
Has anybody threatened you or coerced you?
no.
You're doing this voluntarily
Yes, I am.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Yes.
All right. Get the date. Do I have hang on a quick second. There's a copy for you. No. What? On the date of December 9th, 2025, at the location of 456 Haynes Street in Ypsilanti Township, Washtenaw County, State of Michigan. Did you come into contact with a sheriff deputy?
Yes, I did.
All right. And what happened?
I mean, I could start, you know what I'm saying, from when I got out of jail that day. I did receive tried to call for a simple standby. I guess, you know, something in that didn't happen to where I was able to go to the place. But when I went to my place, you know, I was greeted by the officer. He did tell me to stop, and I didn't stop. I ran.
Okay, so the officer was there. This is a place you weren't supposed to be without a civil standby, right?
I mean, yeah. I did
Okay.
for a simple
And so you
standby.
got there and the deputy, you were starting to proceed to it and the deputy told you to stop.
Yes.
And you'd admit that the deputy telling you to stop, that was a lawful command and he was performing his job in doing that, right? And you failed to follow his order or his command,
Yes.
correct? Okay. All right. Sir, I do have to advise you that from the time that I accept your plea to the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would not be, you would not be able to withdraw your plea, and the court would not be obligated to follow any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, not from the defense, Judge.
And have I complied with the court?
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
February 19th at 10 a.m. before Judge Washington.
February 19th, 2026, 10 a.m.
Yes.
10 a.m.
And
before Judge Washington. Yes, sir.
where is Judge Washington's court? Is this the same building?
No, it's not in this building. It's over off of Huron River Drive in Ypsilanti Township.
I'm not,
Okay, what happened is you can call over to the court. I think it's on that sheet, the 14B.
is that by, Kroger's, if I'm
Yep.
not mistaken?
The Kroger's and,
Is the post office right there?
yep,
Okay,
you know where,
I know.
yep,
Yeah,
that's,
because we had to go get our mail. We stayed in Arbor One in there. Yeah.
got it.
Yeah, I got-
Okay, yep, it's that court right down the street.
Okay.
Okay,
Sir.
all right.
As we move toward the end, the case expands beyond the courtroom and into real-life complications. The defendant's work situation suddenly becomes a major issue, with travel requirements clashing against legal restrictions. There's confusion, missing information, and pressure building as time runs out. The judge steps in again, not just as a legal authority but as a problem solver. What follows is a careful balancing act, ensuring the law is upheld while giving the defendant a chance to maintain employment. The final decision allows conditional travel, which feels like a rare moment of flexibility. It's a grounded ending that shows how justice and reality often collide.
Thank you, sir.
February 19th at 10 a.m. Okay,
Yes.
I got it on here. Thank you.
Okay, thank you.
Call that number.
Robinson.
He's waving.
Yes, Your Honor, there was an offer made here for that waiver to waive open plead as charged on this matter in circuit court, as well as at the next hearing on his other felony matter. It's an Arno, except for this Thursday, leading to an attempt Arno as a global resolution on that one. And that file was 26 F5-500FY.
That's set for PCC, or is that set
Yes,
before?
for PCC.
So that's going to be a waiver?
Yes,
That
Judge.
one's going to be a misdemeanor plea at PCC.
Got it. Okay, then I won't try to do that today. All right, I was just going to try to get everything together for him. Oh, but we won't do that. That's, Ms. Burnwell, that's your understanding.
Yes, Judge.
Sir, you're waiving your right to a preliminary examination in this matter?
Yes, Your Honor.
All right, and you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
You will also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Your Honor, we waive a reading of the information and stand mute.
Defendant having waived formal reading, standing mute as to both counts. Court will enter a not guilty plea. Pretrial will be set for
At 1:30 before Judge Convey.
March 10th, 2026, 1:30 before Judge Kunke.
I didn't hear the name of that, Judge. You said Kunke?
Kunke. Yes.
Okay, thank you, Judge. There's one more matter.
In this case,
Yes,
is it bond?
my client had, yes,
He's out. You want-
I know, but there's a,
No.
he wants permission to travel.
To where?
So. he
So,
works-
no, so if I don't like the place, then no. No. Where's he want to go?
Your Honor, this is the situation. He works for Amazon. We all depend on them, right? Well, they're going in teams, traveling in teams
We.
to different places out
Do I
of state,
depend on Amazon? Yeah,
Practically.
yeah, pretty much.
to different places out of state.
Good.
So he doesn't know exactly where now, but for the next 7 months, that's what they have to do. I guess that's why we get those packages so early.
Mine are always late. Where, no, on the one that's set for PCC. What is that charge?
I'll have to look.
Obstructing.
The PCC matters of resisting and obstructing charge.
Okay, because I have, the issue is that I have a bond violation technically on this one. That results, as I'm to understand, because he picked up the other case.
I believe that's correct. I never received a bond violation report, so that was my understanding was the reason for the violation.
When is he supposed to start the
A week.
travel?
Your Honor, it's within a week that he's supposed to start.
Does he have, you have any documentation indicating that that's it, that you put your hands on today? Because
Emails.
here's the deal. If I don't deal with it today, right, then I lost jurisdiction on this case. And I can't do it. You follow me? So that's gonna be my problem. Then you'll have to get that before Judge Chunky before you can do that.
They won't let me get it. They won't even take me the information because I got the tether on my leg. So they won't even give me the information, the rest of the information because I got the tether on my leg.
Maybe the other alternative might be, well, you're up before me on Thursday, right?
Yes,
For
he's
the
here on the
update.
15th.
So can you put your hands on it by Thursday?
Yeah.
Huh?
Yes, Your Honor.
Okay.
The thing is, they didn't want to give him information because of the tether, because they see this as an impossibility.
Who?
The
Amazon.
job, right?
Yeah.
Amazon.
What did they
Doesn't make
say?
sense. Who the hell?
So basically, so basically with this tether on, they won't give me no information on where I'm going.
Where? So because you have the tether, they'll keep you employed, let you do whatever you're doing.
I've been seasonal. It's seasonal. I'm seasonal worker.
So hold it. Are you currently employed with them?
Yeah, I'm currently employed with them, but I'm going through a third party. We're going out of town. They just sending us out of town. They pay for everything.
I guess I'm not clear on this. So he's kind of employed, or he's employed by Amazon, right? He's going to go do training out of state, right?
Correct.
But you don't have the information regarding that training,
No.
but you think you can by Thursday?
Yeah.
Okay, so here's, because I'm gonna need that to give travel permission on his other case in the event, right? So make sure when you come back on Thursday that you have that information that you can give counsel, okay?
Okay.
And then on this case, I guess since they don't have it, the best thing that
I guess I could bring a motion, an emergency motion.
well, I think, or I don't know
Judge
if the
Cookie.
people have an objection to it.
Your Honor, if I get proof of employment, I'd be more than happy to sit to allow travel for that purpose.
Yeah. So, but, and then you could step and then Judge Kunke could sign it, right? But I don't know when that would happen and if it doesn't happen in time for him to travel. So I know what I'll do. I'll do it this way. What is that other case number?
That's
26F5-5000.
5,000.
Yes,
So 26 F5, 5,000.
yes.
That's the one for Thursday.
Yes.
Yeah.
So I'm gonna do this as kind of does it backwards, but I think we'll get us there as long as you can get the information to us on Thursday. Okay.
Okay, Your Honor.
So what I'll do is I'll continue as bond in this case. But in this case, I will indicate that the defendant may travel as permitted in case 26 F5 5,000 for work purposes. So I've ordered that while I have jurisdiction in this case. It should carry over then when I order it in the other case, you'll have the same travel. Make sense?
Now, my
Thank you.
next question is, can we zoom in for that? Or we have to be here physically?
see what I just did for her client?
You know what, Judge? I'm in
No,
Ann Arbor.
you see what I just did for her client? And then I
You know
do
what?
that, and I like you. She's wearing on my nerves, but.
All right, Judge. I'm in Ann Arbor on Thursday with Judge Slade. So
you were gonna go see Judge Slay and not me?
I realized that.
No.
But if there is like the time conflict, I don't know if it'll be in the afternoon because he is, no, it's still in the morning.
It's at 3 p.m. on Thursday.
Is this? Oh, because it's a bond.
Or just be, no, he's just out of custody.
He's just out of custody.
Yeah.
On Thursday.
He's a good thing about Thursday.
Okay, all right, so what else do you want?
I'll be zooming.
I am trying to, she has time to file the form. I do.
Oh, I have time up until tomorrow?
Today.
You got about an hour and 15 minutes.
Oh, my God. Okay.
Is he gonna want to appear via Zoom also?
It could be.
Yeah, could be.
I can talk to people better when they're on Zoom and I'm on Zoom. When they're in the courtroom, it's like, it's unyoked, is that?
I like people in person. All right. Well, the problem is, he's gonna have to be here because he's gonna have to get me the form, the
Paperwork.
stop, right? So I need him here. You fill out the form if you need to appear via Zoom if you're downtown.
Okay.
That was way longer than I needed to take with that at all. All right. So
Thank you, Judge.
you got that so that we can get your paperwork so I can take a look at all of that. Okay.
That's right.
All right.
Thank you.
All right, folks. Thank you.
I thought I gave the waiver form.
You did. We were trying to help you.
Thank you. I did try.
All right, sir. You're good. Take care.
Thank you. Case number. Okay.
Darn well, you're killing me.